Okay. Can everyone see my screen okay? Yeah.
Yeah.
Tom's nodding. Becky's it. Great. Lovely. Thank you very much. Okay. So our session today is a power download on allegations and investigations. So we are Redway HR. We're an outsourced HR business founded by our wonderful Liz 3 years ago. We deliver high quality but flexible support to a range of different companies. We're a small team of HR specialists, largely based in Hertfordshire, Essex, London, and we work with a range of SMEs and larger organisations. We provide outsourced HR support and consultancy as and when that could be needed to any of our clients. From time to time, employers come from first-time setup to techie entrepreneurs to heritage institutions, including some central London landmarks. We also, as you may imagine, deliver plenty of training and leadership coaching, so to new and experienced managers, as well as day-to-day support and advice that leaders or managers might need. Today's topic is really focusing on how we can deliver out for our in-house clients, but also we're running this free session to give something back to our wider network of people. Of course, we are able to offer services like investigations and hearing disciplinaries and appeals. We've had some particularly thorny ones lately, which do keep us busy, and some rather interesting investigations we've concluded over the years have included things such as an operational director using company finance to fund their lifestyle, MDs expensing luxury family holidays and fleets of cars, but also some of those real kind of day-to-day harassment, bullying, breaches of health and safety, and so on. That's a little bit about us and what we do. So the purpose of today's meeting, we are undertaking an investigation. We're looking at the evidence and the documentation, and we're concluding the investigation and what are those next steps. We'll also do a little bit of a touch on suspension as well as we move on later. So, as well as keeping an eye out for issues around an allegation and poor conduct, it's really the role of the managers to continuously and proactively speak to their staff and discuss any issues, concerns, problems that they might have. This proactive communication can lead to identification of any conduct or capability issues at an earlier stage and really try and nip those in the bud before it kind of escalates to anything bigger. It's a key area of management, and having an awareness of your team, their skills, any barriers, and also their motivators are really essential. So in terms of misconduct, there are different levels of misconduct. We might have ordinary misconduct, as you might say, which could be things like poor timekeeping or misuse of company property. There's also serious misconduct, so that could be things like failing to follow instructions or breaching an internet policy, for example. And then there's instances of gross misconduct as well, so things such as theft or fraud, harassment, unauthorised absence, violence. Examples of misconduct are usually set out in a non-exhaustive list within the disciplinary policy, meaning that each incident can be reviewed individually. So, allegations of bullying and harassment. Bullying and harassment is a behaviour that makes someone feel intimidated or offended. Now, bullying itself isn't against the law, but harassment is under the Equality Act 2010. So this is really when there's unwanted behaviour that is related to one of the following protected characteristics. So that could be age, sex, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, and sexual orientation. The Act also sets out that the unwanted conduct needs to have the purpose of the effect, so violating a person's dignity or creating an intimidating, hostile or degrading environment that someone could find offensive. So just kind of putting that a bit more simply, when someone behaves in a way that offends you or makes you feel distressed or intimidating is harassment. It's also really important that we understand the difference between the purpose or effect. So it's kind of thinking that even banter, even if not intended to offend, it could still have that effect, and it still could be covered by the Act. So, thinking about things that could be deemed as bullying or harassment could include, but again, it's not an exhaustive list, things like spreading malicious rumours, unfair treatment, picking on or regularly undermining someone, denying someone that opportunity for promotion or training, further development, any kind of abusive jokes or comments, graffiti or insulting gestures or even noises. So if we were to think about a situation at a Christmas party, an employer is still responsible for conduct of teams at work events, even if it's not in the office. It's at an event that has been put on by work. Often, so at a Christmas party, alcohol might be involved, which could lead to things being a bit more loose, there being some more banter. And unfortunately, there are instances where that could be more likely to create a situation where someone feels offended, regardless of the meaning of the comments meaning to be offensive. So if, for example, we were to take someone who could be partially sighted, and they've taken a photo and someone says, oh, this photo's blurry, well, what do you expect from the blind girl? That is unacceptable. It's a form of misconduct. There's also a risk of constructive dismissal allegation from the impacted employee and an employment tribunal on grounds of discrimination. It's worth noting that there's no cap on compensation for discrimination with employment tribunals, so they can claim things like loss of earnings, benefits, losses of flow from all leading from that dismissal. They can also claim injury to feelings, which is an award that compensates for hurt feelings caused by any discrimination. So just to kind of give you some insight into what that could look like financially. So for more serious cases of discrimination, we've seen awards of between £25,000 to £45,000. For less serious cases, the band is kind of between £9,000 and £25,000. And then for minor harassment and discrimination claims, an award could be in the region of £900 to £9,000. So could be quite costly to employers. So we'll look firstly at formal action. So some 3 steps really. Step 1 is going to be to investigate. We're going to gather the facts and assess if there's a case to answer, essentially. Step 2 will be then to hold a disciplinary hearing where the employee would be invited to discuss the allegations made against them. Where necessary, apply a suitable sanction in line with the disciplinary process. So that could be something like a written warning, a final written warning, or dismissal, for example. And then step 3 would be an appeal. So this is a hearing where the employee can set out their disagreement with the disciplinary outcome, essentially. They can raise the reasons for that disagreement, and they can also bring forward any new information that could act in their defence, essentially. Each stage should be conducted by a neutral party. It's worth having a plan ahead of time for who may conduct each stage, should it get to stage 2 and stage 3. And where this is done internally, ensure that those involved in hearing any of those, chairing or hearing any of those meetings, have got the training and ability to do so. A key is maintaining confidentiality and impartiality as well. External investigations are often carried out for smaller companies who may not have the resource to conduct an investigation or a disciplinary process, or perhaps in situations where the allegations could be against a senior member of the business or indeed the HR team. I'm conscious I'm flying through the slides. Just wanted to kind of stop and check if there was any questions at this point in time. I will take that as a no. Okay, I will continue. So if we start off with that investigation stage, this is really a fact-finding element of the process, essentially, and it's aimed at collecting the relevant information that supports or goes against, indeed, the disciplinary allegations. The investigation needs to be fair and reasonable. I cannot stress those words enough. The more serious the allegation, the more thorough the investigation is needed to be reasonable. So some case law is around NHS 24 versus Pillar. An employment appeal tribunal found that an investigation won't be deemed to be unreasonable where it is too wide unless it's overzealous or unfair. So we're really asking within that investigation for the person conducting the investigation to take a view and be reasonable with that view. It's really important that the person carrying out the investigation is independent and impartial, as I've mentioned. This is really to ensure that the process is as fair as possible. It's the investigator's job to gather all relevant information. So that could include holding investigation meetings or interviews with employees to establish facts, to interview other witnesses or parties that have been identified, to review any documentary evidence. So that could be things like email trails or policies, for example, and then any physical evidence, so things such as CCTV or computer records as well. For some serious cases or more cases involving that are a bit more techy and technical, you could even get a forensic team to review data entry logs, for example, or locations or computer systems and things like that. So all things to consider of how to carry out a really complete investigation. So if we think at the moment about witnesses, so witness statements or interviews can be really useful. They can gather evidence relating to those allegations. So notes of a witness interview, they don't have to be word for word, but they should accurately capture the points of the discussion. Recording the meeting is also can also be useful, or using an audio device to capture that meeting as long as the policy allows, or with the agreement of the interviewee. As a side note to that, it can create some unnecessary complexities with having recordings. So knowing, a witness knowing that they're being recorded, it could be intimidating to an interviewee. It could make them feel less able to talk openly about the matter. And it also could be quite time consuming because a transcript or recording will usually then need to be typed up. And then this would be used as the witness statement. In some instances, an interviewee may ask to record the meeting, and whether or not a meeting can be recorded is up to the employer to decide. It's really important to ensure a consistent and fair approach is taken. As an employer, you should make your position very clear within policies and procedures as to what that stance is. Any covert recordings of an investigation could be viewed as misconduct, or indeed a breach of trust and confidence. And that could again be from either party, any kind of covert recording from the employer or the employee. It's also worth absolutely noting that any recordings would need to be guided by the GDPR regulations. This, of course, will need to comply with what that looks like internally in relation to your GDPR approach. So that's also something to consider around recordings. After the meeting, it's really important to provide the interviewee a copy of their statement and seek agreement that it's accurate. So asking them to sign and return is a really good way of doing this, or even agreeing via email. You've got that in black and white that they have agreed to the content of the notes that you've shared with them. So then it's time to consider the facts. From the meeting that you've gathered, is there anything additional that you've discovered? Does the evidence already collected support what you have been able to establish from this meeting, or does it contradict it? You can also consider the meeting. Within the meeting, have there been any other suggestions or indications of the need to gather further evidence? So whether that could be arranging other meetings with other members of the business to be interviewed as part of this process. So during an investigation interview, you should firstly introduce the attendees by name and explain their roles, explain the structure, the status of the meeting, agree the note-taking procedure, so whether that is going to be via a recording, whether that is going to be typed notes, non-verbatim, may I add, typed notes that will be shared after the meeting for them to review and sign, outline the allegations as necessary, and then, allow the employee to state their case and provide evidence. So asking open questions throughout, asking where there's additional or mitigating information, if that should be taken into account, and also adjourn where necessary. It's absolutely fine to take a break, gather your thoughts. Sometimes you conduct these meetings and you think it's going to go one way and it goes the complete other. So you need to have a moment, gather yourself, reevaluate the questions that you still have to ask, decide whether you have any other questions you'd like to ask, and then re-adjourn the meeting. And equally, the interviewee can request for the meeting to be adjourned as well. And sometimes you can see this happen if someone becomes quite upset. It might be a good opportunity for you to recognise this and suggest an adjournment, or indeed they can ask to have a break and pause, which is absolutely fine. It's all about being fair and transparent throughout. And also listening to everything they're saying, actively listening, observing their body language and asking open questions to really gather as much information as possible.
We have a question in the chat. Employee has the option to bring someone into this particular stage of the process in this meeting.
If they would like to, they can bring someone with them, absolutely, a representative. Any representatives do need to be within the business, or they can also be a union representative if they're part of a union. We tend to see this more so as the process moves onto into a formal disciplinary process, for example, but by all means, we would want to make sure that someone feels comfortable during an investigation meeting. And if that is by having a team member with them to support them, then you can absolutely consider that. Thank you, Tom. Does anyone else get any other questions? Okay, I will move swiftly on. So again, keeping on this investigation stage, and if we think about reluctant witnesses, so I've mentioned sometimes recording may mean that a witness isn't as forthcoming with information. But what can you do about that? An investigator can try and explore with the interviewee or the employee why they're reluctant to give evidence. Try and provide assurance and seek to resolve any concerns with them that they may have about sharing their experience or giving you some more information about a particular allegation or situation that they may have been witness to. An investigator, where possible, should try to avoid anonymising witness statements. This is because an employee under investigation is likely to be disadvantaged when evidence is anonymised, because they won't be able to effectively challenge that evidence against them. So if you can try and avoid that, then that would be absolutely recommended. Only really in exceptional circumstances where a witness has a genuine fear for retaliation should an investigator agree that the witness statement can be anonymised. If the matter were to progress to disciplinary or appeal and past appeal into legal proceedings, then it's necessary that in the interest of fairness, the employer may need to disclose the names of any anonymous witnesses. So if you can avoid that from the very start, that is preferable. So the kind of final stage of an investigation is the report. So this will be collating the evidence that has been presented in the investigation report, and should really conclude if there is a case to answer, essentially. So you want to think about terms of reference. So the allegations, that could be allegation 1, 2, and 3. Hopefully there's no more than that. Usually it's kind of between 1 to 3 allegations, but it really is case dependent. Then reviewing the bulk of evidence that you've gathered and putting that into an appendix. So the statements that you've gathered, any documentation that's been provided, the documentation that you have also gathered, appendicize that so that it can really easily be referred to within the report, and also found by any future investigating managers. You want to establish the facts. So X and Y were at the Christmas party, for example. X did speak to Y in that way, and Y was clearly visibly upset about it. So you really want to lay out what it is that the facts that you found. Also, you want to state whether there's any other information for that you've taken into consideration. Are there any mitigating circumstances? Has there been any evidence you couldn't gather because a witness was not available, for example, is worth noting within that report as well. And then you want to conclude, is there a case to answer? Sometimes things aren't as cut and dry as yes, there is, no, there isn't. It could be, yes, there's a case to answer for allegation or term of reference 1 and 2, but there's no case to answer for allegation or term of reference number 3. So there isn't a requirement to have an oversweeping yes or no. It can be more detailed in relation to the particular allegations. And then you can set out any organisational learning points as well. So whether a policy needs to be updated or whether you recommend that maybe some training needs to be set out for employees or a certain team, or whether there needs to be a reminder across the board about behaviour at office parties and what's acceptable, what's not, if I'm just kind of, again, using that theme of Christmas party as an example.
Is there a question from Mark? I heard the microphone go live. Oh, no, so sorry. It's just in case. It's all good. Go on.
So sorry about that.
No, it's all good. Just didn't want to miss any questions if you had one. It's all good.
Brilliant. Thank you. Thanks for flagging, Tom. Okay, so we have come to the end of an investigation. Now we want to think about suspension. The ACAS Code of Conduct states, in cases where a period of suspension with pay is considered necessary, the period should be as brief as possible and it should remain under review. It should be made really clear that the suspension is not considered disciplinary action. So when might you consider to suspend? If it's needed to ensure the matter can be investigated properly. Does it remove the individual or other employees from risk as well? That's something to think about. If there's no other alternatives, sometimes it can be an interim solution whilst investigating or indeed conducting any further process at the back of an investigation to move the person into a different team or to restrict their duties. So if there isn't the realms to do that or the scope to do that, then perhaps suspension is something that could be considered. As suggested in the code, it should only last as long as needed for the investigation and or disciplinary process to be undertaken. And also, depending on the allegations, when deciding on when to suspend or if to suspend an employee, some considerations may want to be thought about in terms of their access to systems, servers, things like the payroll system, any CCTV, things like that, which could, potentially put the company at risk if the employee is is disgruntled. And again, whilst making those considerations around suspension, it's really good to keep at the forefront of your mind that it can be damaging. It can have an effect on the employee being suspended. So is that going to impact any process that you're undergoing? But you should also use a suspension letter to outline the rules during any such period of suspension. It's also advised to keep suspension confidential, and again, as noted within the code, review it on an ongoing basis. So again, a little bit of case law here. So Whitaker versus the governing body of Sutton Oak Primary School, an employment tribunal highlighted that a suspended employee and the representative should have been involved in suspension reviews to allow a consideration of whether the suspension should be continue or not, essentially. So keeping regular contact with an employee that is suspended and keeping them involved in those conversations is really key. So inviting someone to a disciplinary hearing. Should an investigation tell you that a disciplinary is the next step, essentially, you've got a case to answer. You want to start off by sending an investigation letter, an invitation letter, should I say, in good time, with a hearing date, time and location. So I say in good time, it's where possible, give the person more than one business day. Where you can give them numerous business days is absolutely brilliant. Make sure the letter states allegations against them and sets out possible consequences or sanctions, so they have complete transparency as to what it is they are going to be discussing. Where you can, provide copies of the documentation or information that will be used in the hearing, and advise the employee that they have the right to be accompanied. So again, that kind of relates back to that question that was asked earlier on at this time, when you're in a formal disciplinary, they do have the right to be accompanied. Anything prior to that is goodwill as such. Why do we need to do this? So that they can prepare their defence. They can come ready. It can be hopefully a useful conversation for both parties. And if they're unable to be prepared, have fair time to prepare, have someone with them to ask questions on their behalf, it could be deemed as unfair. So you then conducted your disciplinary meeting, and it's now time to share an outcome. So at this stage, you will be looking to provide the employee with an outcome letter that will explain what the outcome is. If there's a sanction, for example, what the sanction is, any warning, and how long that will last on their record for. What the standards of future conduct and behaviour are. Like, what are you expecting to see in the future? What is not acceptable? What potential consequences of further misconduct is, particularly during that period of time where they may have a sanction marked on their record. So if there's any further misconduct, what would then happen? And of course, that they have the right to appeal. And how they do this as well. So any decision on a disciplinary, that person can appeal the decision. And in an appeal hearing, the person carrying out the appeal, they'll need to, again, similarly to a disciplinary meeting, introduce everyone, explain why they're there if necessary, and explain the purpose of the hearing, how it will be conducted, and what the powers the person hearing the appeal has. So you would want to be asking why they're appealing. You want to be looking at any new evidence that they're supplying, if there is any. And not doing all of the above could lead to an unfair dismissal claim. So again, it's just about being super transparent throughout the entire process and being really, really fair. After any such appeal, whatever the decision is after an appeal, that is the final decision. And that will end a process. At the very last step, after an investigation, there could be the decision that there's no case to answer. The process would be ended at that point. If there's a disciplinary outcome, as seen by the investigation, and the person accepts the outcome, which could be a formal warning, and they wish not to appeal, then that will be the end of the process. So there could be an end of the process at each 3 of those steps, but the absolute final part would be the appeal. So some key takeaways really from today's session is making a decision and being really reasonable in your thought process, getting up to that decision, and in the decision-making process too. Does anyone have any questions before I wrap up the session? Okay. Well, thank you all so much for your time today. I really appreciated it. Moving forward, managers should be competent to undertake these processes. If you are concerned that there is any gaps in skills or knowledge, we do offer half-day training on investigation and disciplinaries that goes into a lot more depth and detail. For line managers and leadership, we can offer a 10% off the usual price of £1,150 plus VAT if you sign up within 7 days of this webinar. And again, if anyone attending this session would like 15 minutes of free HR advice, please do feel free to get in touch with myself or Tom, and this can be arranged for you with myself or another member of the team. That 15 minutes doesn't just have to be about this session. It can be about support within the process. It can be about anything people related. Okay. And just finally, to make you aware, we do have an online learning platform which can be really helpful and provide low cost training for some key areas across the business. So things like equality, diversity and inclusion, and also sexual harassment training too. So we'll make sure that it supports you with compliance and legislation. We went live in October with this. It could be really low cost, accessible via screen reader, and booked and used within 3 months. Okay, so if there's any bulk purchases, then we can again offer some discounts there. So for anywhere between 10 and 50 employees, we can offer a 25% discount, and for any orders between 50 and 100 employees, we can offer a 35% discount. Okay, so just to make you aware of some other ways that you can we can support and provide some guidance and training for you as well. Okay. So thank you very much again for attending today's session. It's been a pleasure. And does anyone have any kind of final thoughts or questions?
We have some typing in the chat.
Okie dokie, thank you.
Oh.
I will stop sharing my screen so I can see you all. Bye.
So the question is, the half-day line managers training, is that a price per attendee or for a group?
For a group. Thank you.
There we go. Yeah.
Brilliant. Okay, well, if there's no other questions or comments, is there anyone typing, Tom? Can you see?
Just a thank you from Mark.
Brilliant. Oh, thank you, Mark. Thank you so much for taking the time. It's been a pleasure.
And a thank you from Morgan as well.
Brilliant. Thanks so much, Morgan. Thank you to all who took the time to attend. Hopefully we'll see you again on future Power Download sessions. And yeah, thank you and take care.